Good afternoon again, everyone. This is Kate McMahon and Lindsay DeSalvo. We'll be presenting Con Maciel Carey's webinar this afternoon on employee complaints and how to address those complaints in the context of whistleblower claims, OSHA notices of alleged hazards, and rapid response investigation responses. We welcome all of you. We're glad to have you here. For those of you who don't know me, my name is Kate McMahon. I'm a partner in Con Maciel Carey's OSHA Workplace Safety Practice Group. I'm here with Lindsay DeSalvo, who will introduce herself. We are going, just by way of background, I've spent many years as a practitioner in the OSHA and before that environmental law space. I have spent a good chunk of my career representing employers in with health and safety issues, either in the context of policy issues that are addressed here in DC, rulemakings that have sometimes broad impact on industries, and individual enforcement actions. I spend a good part of each day helping clients with compliance questions, advising on risk management strategies and programs that companies are developing that are above and beyond OSHA regulatory programs. But from time to time, our clients need help with an enforcement action, and I get involved in those as well. So that's a little bit of background. I'm going to immediately turn this over to Lindsay DeSalvo, my colleague, who is going to introduce herself and then begin the discussion in today's webinar dealing with whistleblower complaints.
All right, good afternoon, everyone. As Kate said, my name is Lindsay DeSalvo, and I'm an associate here at Con Maciel Carey in both the labor and employment and OSHA practices. As an OSHA practitioner, I represent employers during inspections and enforcement actions. I also advise and counsel employers in responding to Section 11C whistleblower complaints, as well as notices of alleged hazard, which we'll talk about in more detail today. So here's just a brief agenda outlining the topics that we'll cover. The first chunk you'll see, and this will be a lot of our presentation today, is different issues related to 11C whistleblower complaints. So first we'll sort of go into what Section 11C of the OSHA Act does, what it is, and how a complaint under Section 11C works. Then we'll talk a little bit about some recommendations for responding to Section 11C complaints, as well as how to potentially avoid a whistleblower claim filed with OSHA. And then Kate will also spend some time reviewing OSHA notices of alleged hazards and suggestions for how to respond to those, as well as OSHA's rapid response investigations related to reports of serious injuries. So Section 11C of the Occupational Safety and Health Act prohibits employers from retaliating against workers who, in good faith, attempt to exercise one of the rights that is protected by the OSHA Act. It also gives employees certain protections as well as remedies that they may be entitled to if they are able to show that impermissible retaliation did occur under the OSHA Act. So OSHA's whistleblower role is actually broader than just enforcing Section 11C of the OSHA Act. OSHA has authority to enforce whistleblower standards under 22 different statutes. Some of those statutes include environmental laws like the Clean Air Act and the Clean Water Act. They also include the Sarbanes-Oxley Act and the Affordable Care Act. Each of these laws has its own, provision prohibiting retaliation, and so OSHA is responsible for enforcing those provisions and investigating complaints related to those provisions under each of the individual acts. Interestingly, most of the retaliation claims that OSHA receives are actually brought under Section 11C of the OSHA Act, and we'll look at some stats on that in just a couple slides. So this slide shows the language of Section 11C of the Occupational Safety and Health Act. You can see that it's a very broad provision prohibiting discriminatory treatment of employees who exercise their rights under the OSHA Act. The language of the statute does include some examples of the types of rights that are protected from retaliation by the OSHA Act, including filing a complaint with OSHA, providing testimony related to an OSHA enforcement action, or instituting an enforcement action with OSHA. But there is sort of this catch-all provision at the end that basically says that any right afforded to an employee by the Occupational Safety and Health Act could be the basis of protected activity, and employers would be prohibited by the OSHA Act to retaliate against an employee for exercising one of those rights. This slide shows some stats for the types of complaints, retaliation and whistleblower complaints that are filed with OSHA. So these are the laws that OSHA is charged with enforcing through its whistleblower enforcement authority. You'll see that the OSHA Act, or Section 11C of the OSHA Act, has the greatest amount of complaints filed. It has gone down a little bit in the past couple of years, but still, about 5 times greater number of complaints that are being filed under Section 11C of the OSHA Act versus the next closest laws under which employees file complaints that would be enforced by OSHA. Significantly over half, about 62% of the whistleblower complaints that OSHA receives are under Section 11C of the OSHA Act. And you'll notice that for the past about 5 years, OSHA has received over 1,700 complaints under Section 11C. So, not a huge amount, but significant, and definitely significant for the employers who are actually facing complaints filed against them under Section 11C of the OSHA Act. This chart shows how these complaints are concluded. You'll see that a vast majority of these complaints, about 71%, are either dismissed by OSHA based on the evidence that they see during their investigation, or even earlier if the employee does not meet the time requirements for filing a complaint under Section 11C. And then another huge portion of that 71%, about 22% of the complaints filed are actually withdrawn eventually by the employee. Notably, about 29% of Section 11C whistleblower claims do end in a positive outcome for the employee, either through a merit finding by OSHA, which is actually a very small portion, as you can see, only about 1%, or through settlement between the parties. And this is important to employers from both a financial and practical perspective. Under Section 11C of the OSHA Act, employees can be entitled to certain remedies, like reinstatement. If an employee is discharged, and that's the adverse employment action that occurs, they could be reinstated to their employment, which obviously could have some pretty significant practical impacts for the employer and the employer's workforce. They could also be entitled to back pay, as well as front pay in certain circumstances, compensatory damages, and punitive damages if they can show what OSHA has termed as evil motive or callous indifference on the part of the employer. In those cases, they could also be entitled to punitive damages. So a whistleblower claim is initiated when an employee or a former employee or a representative of a worker, which could be, like a union representative, or it could be a close family member like a spouse, files a complaint with OSHA alleging that retaliation occurred based on activity protected by the OSHA Act. OSHA actually provides an online system through which employees or employee representatives can file a complaint. Such a complaint could also be filed by contacting OSHA by phone, as well as by making a complaint in person at the area office. That complaint has to be lodged within 30 days of the time that the adverse action occurs and also importantly, at the time that the employee becomes aware of the adverse action or has knowledge of the adverse action. So the employee has to be aware that the adverse action occurred for that 30-day trigger to start. This period could be told under certain circumstances. For example, if the employer concealed or misled the employee as to whether an adverse action had actually occurred, this could extend that period of time. Or in certain very limited circumstances, if there was some debilitating illness or injury that prevented the employee from making the complaint during that 30-day period, OSHA may take that into consideration as well. So both OSHA guidance and Section 11C of the OSHA Act direct that an investigation should occur within 90 days and that a determination on the complaint should occur within 90 days. I can tell you from experience that it's very rare circumstance where the investigation and determination will actually happen within 90 days. We've had cases that have taken up to 6 to 8 months to get a determination, or even longer. Sometimes I think cases kind of get put on the back burner and revisited later, and in those circumstances it will definitely be longer than 90 days to actually get a determination. But technically that is the period in which a determination should be made. During that time period, the investigator will review the evidence that is provided, both documentary evidence from either the employee who has made the complaint or from the employer during the process in which the investigator will ask for documentation from the employer. The investigator might also interview different individuals related to the complaint. They will definitely interview the employee who has actually made the complaint. They may also ask to interview certain representatives of the employer, depending on who is involved and who is identified in the facts that are provided by both the complaining employee and the employer. So it could be the employee's supervisor, it could be any witnesses to the facts that the employee or the employer provide. And then finally, the investigator will also request certain information and documents. Like I said, this is usually pursuant to a position statement and follow-up on the part of the employer, but the investigator may also ask the individual employee if they have any documents, though usually that documentary evidence is going to come from the employer. Importantly, it's good to know that the OSHA Act does not provide a private cause of action for whistleblowers. Only OSHA can bring a whistleblower complaint, can pursue a whistleblower complaint, and bring a whistleblower complaint to a federal court if it gets to that point. Thus, if OSHA reviews the evidence and determines that there's no basis for a whistleblower complaint and decides to dismiss the complaint, the employee has the ability to appeal such a decision. But if OSHA stands by its decision, even at the appeal level, and decides that there's no support and it ultimately dismisses the complaint, the employee has no further recourse under Section 11C. They may attempt to bring another claim under a different law, but under Section 11C, they would not have recourse or the ability to bring the complaint in a federal court on their own. So this slide shows both the old and new standard that OSHA uses to assess whistleblower complaints. Prior to 2016, the complainant or the complaining party actually had to establish a prima facie case of retaliation in order to maintain a claim and to proceed through the OSHA investigation and potentially beyond, depending what OSHA determined. So they had to prove that prima facie case. Now all an employee has to do is establish, and this is from OSHA guidance directly, they have to establish a reasonable cause that a complaint has merit, and OSHA will make that assessment by looking at the evidence provided by both sides or otherwise gathered during the investigation. So in other words, now a complaint could potentially go forward even if there was only reasonable cause to believe that a violation actually occurred. So this is a lower standard than the standard that OSHA was using prior. It does give more leeway to employees to pursue a complaint. At the same time, this is a lower standard than would be used by a judge if it got to a point of a hearing, an administrative law judge. So even if it did get to that point, if the employee could not actually establish a prima facie case, they would ultimately not be successful in the complaint. But it could, go further in the process under the reasonable cause standard, and OSHA could choose to pursue it to the point of a hearing if they think that the evidence establishes reasonable cause to believe a violation occurred. This slide shows the main elements of a whistleblower complaint under Section 11C of the OSHA Act. You'll notice that these elements are similar to elements that you would see in the case of other types of retaliation claims. OSHA does include knowledge as a separate element, which is not the case for some other types of retaliation claims. According to its guidance, knowledge is sort of a specific separate element that is considered in determining whether a complaint is valid. And you'll see the first one is protected activity, and we'll go through each of these in a little bit more detail throughout the presentation, but just to give you sort of a baseline, the employee does have to establish that he or she engaged in activity that is actually protected by the OSHA Act. They must also show that the decision maker had knowledge that the protected activity occurred, that there was an adverse action, and that the adverse action and the protected activity are linked, that there's a causal connection between the protected activity and the adverse employment action that they ultimately face. So here are some examples of what is considered protected activity under the OSHA Act. This is not an all-inclusive list, but these are sort of the main things that we see as the basis for a Section 11C complaint. Particularly, the first bullet point you see in the third are the ones that I would say, at least I've seen most often, as the basis for a whistleblower complaint. So making a workplace safety complaint to OSHA. This could be in any form. The employee contacts OSHA to let them know that there is some hazardous condition at the work site. Even if it is determined by OSHA that there isn't actually a hazardous condition at the work site, if the employee in good faith made that complaint could still serve as the basis of a Section 11C whistleblower complaint. And then the third one, complaining to the employer workplace safety concerns and issues. This is something that can occur quite frequently, and it could be the basis of a Section 11C activity, even if the complaint isn't ultimately made to OSHA. If the employee can show that they did, again, in good faith, make a legitimate safety complaint to the employer, and then thereafter they can allege that they were retaliated against, that complaint to the employer could be the basis of an 11C whistleblower claim. And then you'll see here also participating in OSHA enforcement action. This could be, if an employee is interviewed during an enforcement action, and that information serves as the basis of a citation, or even if it doesn't, their mere participation is a protected right under the OSHA Act, and then as well as testifying in a deposition or hearing if an enforcement action got to that point. As I said, OSHA does require separately that there is some evidence of employer knowledge. This is something that's often, I think, in other forms of retaliation analyses included in the causal connection consideration, but OSHA considers it separately here, and basically an employee would need to be able to show that the decision maker, whoever decided to take the adverse employment action against the employee, knew of the protected activity at the time they made that decision. So if the decision maker, if the supervisor, for instance, wasn't aware of the protected activity, wasn't aware that the employee had made a complaint to OSHA, for example, then even if they were the ones that took the adverse employment action, or even if they took an adverse employment action, there would be no way to establish that the protected activity had anything to do with it if the decision maker didn't have knowledge. Conversely, if the decision maker did have knowledge of the protected activity, that could weigh in favor of the employee's ability to be able to show that there is support for their 11C whistleblower complaint. So what is an adverse employment action? The employee must be able to show that the action might have dissuaded a reasonable worker from making or supporting a charge of discrimination or retaliation. So in other words, if the adverse action could make a reasonable employee choose not to otherwise take that action if they knew that this were the consequence, that would be sufficient to show that the action was adverse and meets the requirements to go forward with a whistleblower complaint. And there are two main elements here that OSHA is going to consider in analyzing whether the action taken was actually an adverse action. And that is, first, whether it was materially adverse, and this goes to the idea of whether it would have dissuaded a reasonable employee, and whether it was materially adverse to a reasonable employee, applicant, or former employee, whatever the case may be, as far as who is actually making the complaint. These are some examples of adverse employment actions. Some of these are, I'm sure, sort of very obvious, the types of things that would normally serve as allegation of retaliation. And discharge is the one that I would say comes up most often. A change in duties could be sufficient to rise to the level of an adverse action if, for example, the employee had important duties, significant duties that were removed from them after some protected activity. That could be sufficient adverse action. A poor evaluation, after the employee makes a complaint to OSHA, the next evaluation that they receive, they get very low marks where maybe that wasn't the case in the past. That could be a sufficient adverse action. And then the second box here are some things that OSHA specifically lists in their guidance as forms of adverse action. Harassment by a supervisor or manager, threats to the employee after they have engaged in some form of protected activity, intimidation, don't make these types of complaints in the future, that sort of stuff. And then also potentially a suspension or reduction in the employee's hours could serve as an adverse action, particularly under Section 11C of the OSHA Act. There is also some case law that has stated that actions that impinge on an employee's future employment could be considered an adverse action. For example, giving an employee a negative reference. That could be an adverse action if it does, sort of impede them from being able to get alternative employment, or maybe employment generally if they have been discharged. And then the last element that an employee must be able to show to support a whistleblower complaint under Section 11C is the causal connection. And specifically for Section 11C, and this is similar to Title VII of the Civil Rights Act, the employee must be able to show that but for the protected activity that they engaged in, the adverse employment action would not have occurred. OSHA's whistleblower manual makes clear that although the but-for test is more stringent than other causation assessments related to other statutes, it does not require a showing that the protected activity was the sole but-for cause of an adverse employment action, as long as the employee can show that it was a but-for cause of the adverse employment action. That is sufficient to be able to establish a causal connection between the protected activity and the adverse employment action. And again, as I said a few slides ago, the overall burden that has been put on the employee to establish the facts necessary to support a Section 11C complaint has been lowered. So the but-for standard is more stringent than some other laws, but again, the employee overall only has to show a reasonable cause that the violation occurred. One of the, I think, most common ways that an employee can establish a causal connection is through proximity. So this is the idea that the adverse employment action occurs within a short period of time after the protected activity. And the Supreme Court has held that a 3 to 4 month period between protected activity and adverse employment action is usually going to be insufficient to establish a causal link. That 4 months is probably too far out from when the protected activity occurred, but this can be different. It is definitely case dependent. OSHA is not necessarily bound to that specific period. It'll be dependent on the specific facts. If there's a reason maybe it took longer to get to the point of an adverse action occurring, maybe the employer didn't have knowledge of the protected activity till a little bit after it had occurred. That will all weigh into whether proximity is sufficient to support a causal connection. But if the employee makes a complaint to their employer about some sort of safety issue and then within a month is terminated or is suspended or is demoted, a month would likely be sufficient to establish a causal connection based on proximity. Though OSHA would also consider other facts and evidence related to that. If an employee is able to establish those elements of 11C whistleblower complaint, the employer then has the opportunity to counter that evidence by showing that whatever adverse action was taken was based on a legitimate and non-discriminatory reason. This, similar to Title VII, is a burden of production. The employer just has to provide the reason. Usually, you're going to want to provide evidence to support that reason, but the burden for ultimately proving the claim always rests with the employee. However, if the employer can show that they took an adverse employment action because of insubordination or a violation of company policy or a company rule, this is going to generally defeat what the employee was able to establish unless they can show that the legitimate non-discriminatory reason was simply pretext for the retaliatory intent. So now we'll talk briefly about some recommendations and suggestions we have for actually responding to a Section 11C whistleblower complaint. So let's say a complaint has been filed. OSHA has given the employer, sent the employer a letter stating that a complaint has been filed under Section 11C of the OSHA Act. These are some of the things that we would recommend doing pretty immediately after receiving notification from OSHA. First, if the worker is still employed at the company, it's just making sure that there are now no retaliatory actions taken against the employee for filing a Section 11C complaint. This can be as simple as just reminding managers, don't take any action that is going to be perceived as retaliatory. Obviously, if the employee is insubordinate or violates a rule after they have filed an 11C whistleblower complaint, the employer still has a right to take legitimate disciplinary action, but they just want to be aware and careful about how they treat the employee after receiving information that a complaint has been filed. The employer is also going to want to conduct their own investigation of the claim. So the employee, when they file the complaint, has given OSHA a bunch of facts or alleged facts and information related to the basis for their complaint, and the employer has to be able to respond to that. And the best way to do that, the most effective way to do that, is to conduct your own investigation related to the allegations of the complaint. So the first thing is assessing whether the complaint was timely. A pretty quick and easy way to get a whistleblower complaint dismissed is to show that it was filed outside of that 30-day period. So to the extent the employer is able, through its investigation, to determine that the employee was aware of the adverse employment action maybe 45 days before they actually filed the whistleblower complaint, that could be very helpful and something to put right up front in the information shared with OSHA. Employers also going to want to collect documents related to the claim. This could be if the employee was terminated for violating a policy, the employer wants to make sure they have a copy of that policy, they understand that policy. They want to have a copy of any disciplinary action or disciplinary form that might have been completed, a copy of any documentation supporting a decision to demote an employee, for instance. Those are the kinds of things that the employer is going to want to collect and maintain for potentially providing to OSHA to support their version of what occurred, as well as to just make sure that they are thoroughly documenting an investigation of the complaint. Employer will also want to interview employees that have knowledge related to the complaint. This is often going to be maybe the complaining employee's supervisor, any non-management individuals who may have witnessed or been a part of the facts related to the complaint, HR personnel, and any other decision makers who are involved in deciding to take whatever adverse employment action is the basis for the complaint. And then finally, the employer wants to make sure that this investigation and its findings are recorded, not only because, generally employers have a policy to conduct investigations of these types of issues, but also this will help in the employer's development of a position statement in response to the whistleblower complaint when requested by OSHA. And that leads into our last bullet point here, is the employer will want to prepare a position statement or response to the complaint. And when OSHA notifies the employer that a complaint has been filed against it, usually they're going to provide a date or a deadline by which they expect the position statement at that time or shortly thereafter. So we have here two primary goals that the employer wants to try to meet in putting together their position statement. And the first is to give context to the charging party's allegations. So at this point, all OSHA has heard is the allegations and alleged facts from the complaining employee. And the position statement is the employer's opportunity to give more information about those allegations, to give more context to the circumstances around those allegations. This is also the opportunity for the employer to tell their story, tell their narrative in a way that's easy for the investigator to follow. You want to provide documentation and exhibits usually related to the position statement and the facts provided in the position statement to give support to those facts outside of just the explanation provided in the actual statement. The position statement also allows the employer to demonstrate that they are taking these allegations seriously, that they have conducted their own investigation of the complaint and come to a conclusion on the allegations made in the complaint. And then, it's just generally an opportunity to persuade the investigator that this complaint should be dismissed because it doesn't have the support required to go forward. So in the position statement, the way we usually recommend putting it together is to first provide a statement of facts. In this statement of facts, we think it's helpful to start with some information on the background of each of the parties. So from the employer's perspective, what type of company are they? What type of business do they do? And then it's really important here to highlight any applicable policies or procedures, particularly where an adverse employment action is based on a violation of a particular policy or procedure. This is the time that the employer wants to describe that policy or procedure so that later when they're talking about the law related to these facts, it's easy to pull from the facts at the beginning and explain them pursuant to the law. and then also describe the context for the basis of the charge. And this is where the employer will, identify who the decision makers were, why they made the decision that they did, talk about any performance issues that the employee may have had that led to the decision to take the adverse employment action against the employee, any prior discipline that they experienced, or the disciplinary action that ultimately led to the adverse employment action, maybe the demotion or the discharge. And you just want to use this opportunity to basically show how the adverse employment action was lawful and was related to facts that would lead to the decision to terminate the employee or somehow discipline the employee. And then the second main part of the position statement will be the legal analysis. And this is where the employer wants to take the opportunity to show that the employee in some way did not establish those elements that we reviewed before. It may be that the employer can assert that the employee doesn't establish any of the elements. I think that's often not really the case, because maybe there was an adverse employment action taken, but the employee can't show that there's a causal connection between the adverse employment action and the protected activity. Or it could be that the employee didn't actually engage in activity that was protected by the OSHA Act. Maybe the employee complained of a business practice, and if that complaint was not related to safety in any way, then this would be sort of the area of the position statement where the employer shows that the activity was not actually protected activity under the OSHA Act. This is a good place for an employer to get legal counsel involved to help them develop the legal argument and the legal analysis for why there is no support or insufficient support for the employee's complaint, and assist with potentially providing some supporting case law that can show that the employee maybe didn't meet the proximity requirement, for example. And then finally, supporting documentation. So we generally do think it is helpful to provide supporting documentation. If supporting documentation isn't provided with the position statement, there's a good chance that OSHA will request certain documentation. So a lot of times it's helpful to just provide that documentation right up front. And the documentation, like I said, it could include the policy or procedure that the employee is alleged to have violated as the basis for the adverse employment action. It could include evaluations to show that their performance was deficient in some manner, as well as write-ups or disciplinary action that shows that, again, their performance wasn't up to par, that they maybe violated a policy or procedure, and as a result, this adverse employment action was taken. It could also include an affidavit from a supervisor. OSHA may, and a lot of times does, request that they be able to speak to those that were involved in the decision to take the adverse employment action, and that is often going to be the employee's supervisor. So to the extent that up front you can provide a statement from the supervisor to support the allegations in the position statement and the facts in the position statement, that can be really helpful. However, it is important to be careful and considerate about the documentation that is provided, because in some instances the investigator may choose to disclose the position statement to the opposing party. That doesn't always happen, and they may wait to do so until the opposing party actually requests a copy of the position statement, but it could be disclosed, so it's important to consider that fact, as well as the fact that it could also be disclosed to a third party pursuant to a FOIA request. So it's important to not only consider carefully what documentation to provide, but also for documentation that is maybe business confidential, to ensure that they are marked appropriately as business confidential, because this could limit what is provided pursuant to a FOIA request. So I'm now going to turn it over to Kate to talk a little bit about suggestions that we have for how to avoid whistleblower claims, as well as to talk about the Notice of Alleged Hazards and RRI.
Hello again, everyone. I just want to wrap up the discussion on whistleblower claims by really emphasizing a few points that Lindsay has already made. The goal, obviously, is to avoid a whistleblower claim in the first instance. Lindsay has spent some time talking to you about how to deal with whistleblower complaints once they're made, but obviously, ideally, you avoid them in the first instance. The way to do that, from our, based on our experience and what we've seen in the field, we put this slide together: train, train, train. What you want to avoid is your supervisors and your managers not understanding what retaliation is and inadvertently or unwittingly taking action that could legitimately be described as retaliatory. So, in order to avoid that, you want your supervisors and managers to be trained well and thoroughly on what retaliation is and how to manage protected employees. That is, what is the way in which you should manage employees who you may have to engage in disciplinary action for. You want to train your management staff on how to respond to complaints. So if an employee who would be in the protected employee status, if an employee comes to a manager and complains about a health and safety issue, your management should be trained on how to properly respond in a non-retaliatory way to that complaint. Your management should also be trained on what in fact is considered retaliatory. Lindsay spent some time earlier talking about what adverse actions are. We want to make sure that all your supervisors in a position of authority understand what retaliation consists of. It's obvious in certain cases, like firing, but changing someone's duties, for instance, making them sort of have less significant duties. That's an example of a retaliatory action that some supervisors and managers without training might not understand. So train them on the types of actions that are considered adverse. Explain to your management in training about this perception of proximity and about the perception of retaliation and how it relates to proximity in time. So if there is an adverse employment action that needs to be taken against an employee for poor performance or what have you, some non-protected activity, what you want to do is make sure that you strategically make those decisions about taking that adverse employment action in a way that does not set yourself up for a retaliation claim because you did it right on the heels of protected activity. You should make sure that you are sensitive to the perception of retaliation, even if it is not the intent of management. There certainly could be a perception that by the employee who's had adverse action taken against them, that this was in retaliation of for instance, health and safety complaint, or any of the other, protected activity under the many other statutes that OSHA's whistleblower office enforces. So we also think that you should effectively communicate, train your management staff on how you effectively communicate, but how management effectively communicates to hourly employees that adverse employment action. What words do you use? What is the setting in which you explain the adverse employment action? And finally, we want to make sure that your management staff is trained on how to properly and legitimately document the response to the employee conduct. With those trainings in place, you will, in our view, significantly lessen the likelihood of a whistleblower claim being brought in the first instance. Finally, we want to share with you that, based on our experience, prior to and at the time of the adverse action, it's really critical to document every step of that action. It never feels good for an employee to have an adverse employment action taken against them. Never. Under the best of circumstances, it's an awkward to, tragic event for that employee. So if it is being done for a legitimate business reason, you need to make sure that you maintain clear written descriptions of the adverse employment action that you're taking, the disciplinary action that you're taking, from counseling all the way up to termination. You need to make sure that you detail thoroughly the decision-making process. So down the road, if a retaliation claim is made, under the OSHA Act, it's a pretty short time period, but other statutes provide a longer time period. You have a documented written explanation and rationale that explains why and how and when you took the adverse employment action. Finally, we want to make sure that you understand that when you have a retaliation, a whistleblower complaint, you need to also document your investigation of that complaint. And Lindsay went through this, but I want to just emphasize that it's very important for you to take notes, for instance, when you're conducting employee interviews, when you're conducting a whistleblower complaint, that you record the reasons for your outcome determination, and that you provide a written certification of any follow-up actions taken pursuant to that outcome. And apprise the employee who is complaining and who feels that they've been retaliated against the findings that you have made. There's no point in not sharing that with the employee. So that's our recommendation for how to avoid and deal with whistleblower complaints. Now I want to turn our attention to the notice of alleged hazards. What are notice of alleged hazards, otherwise known as phone and fax complaints? How do they come about, and how do you respond to them as an employer? Under Section 8F1 of the Occupational Safety and Health Act, every employee or representative of an employee, a union local for instance, is given the right to complain to OSHA and ask for an inspection of a workplace where that employee or representative believes that there's a violation of a safety and health standard. OSHA has made the process for employee complaints for safety and health alleged hazards fairly simple for employees. There's a form that is available on OSHA's website, Form OSHA 7, that can be filled out by an employee. It's a pretty simple form. We've got a picture of it here on our slide. For an employee to file a complaint with OSHA sharing that they believe there's a violation of a health and safety standard in their workplace. OSHA has an obligation that it takes very seriously to investigate all claims of health and safety violations in workplaces. But that does not mean that OSHA will do an on-site inspection of every health and safety complaint. First, OSHA does do a sort of initial legitimacy review, not legitimacy as to whether the complaint is legitimate and can be documented and real, but whether it's a crank call, essentially. Other than crank calls that just have no backing, OSHA will investigate every single complaint of a health and safety violation. The agency obviously does not have the resources to do on-site inspections for every complaint that comes in, however. So they have to make judgment calls as to whether to investigate on-site, commence an inspection by sending a compliance officer to the site to conduct an on-site walk-around and interview employees, et cetera, which takes a lot of resources and time, or do what are referred to as phone and fax complaints. I want to share with you the criteria that OSHA uses to make determinations as to whether, in that critical moment when they have a complaint from an employee, whether they will go out and do an on-site inspection or rather they will do a phone and fax complaint. First, where OSHA has a written, signed complaint, signed with the employee's name, by a current employee as opposed to, say, a former employee or an employee representative, that provides sufficient detail to allow OSHA to do, at least on a first level, a review to make a determination whether there is a violation or a danger at the workplace that threatens harm to an employee or that an imminent danger exists. In those situations, OSHA will immediately begin an on-site inspection. But it's got to have detail sufficient in that initial complaint to be able to assess at that initial stage without going to the work site that it is likely that there is there's a decent chance anyway that there's an imminent danger or physical harm that an employee or a group of employees is exposed to. Second, OSHA will engage in an on-site activity where an allegation that physical harm has already occurred as a result of a hazard and that hazard still exists. So there's a continuing hazard that is present at a work site where harm has already occurred and could continue to occur. OSHA will show up at the work site to do an on-site inspection. Third, a report of an imminent danger, even if it's not signed by the employee, which, by the way, Form 7 does not require. You don't need to provide your name to the agency if you're the employee. But if there's an allegation of an imminent danger, OSHA in all likelihood is going to show up at the door to do an on-site inspection. If there is a complaint about a company in an industry that's covered by one of OSHA's national emphasis programs or a regional emphasis program or a local emphasis program, OSHA is likely going to show up if the complaint relates to a hazard that is targeted by one of those programs and conduct an on-site inspection. Another reason OSHA will show up at the work site and do an on-site inspection is if the complaint is against an employer who has a history of an egregious, willful, or failure to abate citation within the past 3 years. And, OSHA's got discretion here, obviously. So it could even be in the past 5 years. It could be, in the history of the company. But if there's a citation, an egregious, willful, or failure to abate citation in the last 3 years, there's a high likelihood there will be an on-site inspection. If the complaint is from a whistleblower investigator, that is, if the Office of OSHA that investigates whistleblower complaints refers a complaint to OSHA, that will be a situation where OSHA does an on-site investigation. OSHA will do an on-site investigation for facilities that are already undergoing another OSHA inspection or scheduled to undergo an OSHA inspection, like a programmed inspection, for instance. If you are on a list to be inspected or you are in the middle of an inspection, that complaint will be added to the inspection scope and resulting in an on-site inspection for that particular alleged hazard. And finally, where you initially don't make the cut for an on-site inspection, you receive a phone and fax complaint, which we'll talk about next, but you do an inadequate response for OSHA. That is, you either don't respond, you take too long to respond, or your response is not, convincing or compelling to OSHA. Then OSHA will likely show up for an on-site inspection as a follow-up to the phone and fax complaint. All right, now let me sort of explain the process for phone and fax complaints. The other nomenclature that is used for phone and fax complaints is they're called notices of alleged hazards. That will be what's in the ray line of the letter that you receive from OSHA. The process is as follows. OSHA receives a complaint from the employee or, say, from a whistleblower enforcement office and phones the employer. That's the first step. OSHA calls the employer to report that OSHA has received this complaint from either a current or former employee and or from the whistleblower office, and what the hazard is that is alleged. OSHA will give you the description of the hazard. They will obviously not give you the name of the employee. OSHA then follows up that first step phone call with a notice of alleged hazard fax that is sent to you that conveys the complaint and requests the company to investigate and respond to OSHA to tell them whether that hazard exists and or what you have done about the hazard, how you have corrected it. Typically, in fact, I believe on the federal level it's always the case that OSHA gives 5 days to respond, even in situations where we've handled phone and fax complaints that have, a myriad of hazards alleged that are unrelated to each other. OSHA, in the first instance, provides 5 days a week to respond. However, the agency also understands that investigating these matters, which it wants the employer to do in the first instance, takes some time. So we've not run into a situation where OSHA has denied a legitimate request for an extension. Our advice to you is to do a very thorough inspection. So if that requires an extension of the initial week response time, we recommend that you almost immediately reach out to OSHA upon receiving the notice of alleged hazard and ask, make a determination as to the scope of the investigation and the timeliness or the time frame it will take to complete your investigation. And if it's longer than the week, which it often is, call OSHA up, ask for the extension, and then follow that up with a documented exchange with OSHA where OSHA agrees to the extension. Get a date certain. Ask for however long you think, 2 additional weeks, but make sure you're in agreement with OSHA as to when that time frame runs, and then follow up with an email with the agency where they agree to the extension in writing. Our recommendation is that you post the complaint letter, the phone and fax notice of alleged hazard. Post it where you typically post your, health and safety posters, your employment posters, somewhere that employees, have access to, like a lunchroom, etc. Bulletin board where the time clocks are, something like that. We do suggest that you post the response as well. We want your employees to be aware of the complaint and the response. Now, the reason to post, there is questionable authority that OSHA has as to whether they can require the posting. They certainly have authority under OSHA regulations and the statute to require posting of certain documentation. It's a little questionable as to whether they have legal authority to require this posting, but the agency does say in the letter that they request and require you to post these notice of alleged hazards, and strategically it's our advice that you go ahead and post them. There's a couple of reasons for that. One, you're now in a zone where OSHA, in all likelihood, has authority. It has reasonable cause to come out and conduct an on-site inspection. It's typically not in an employer's interest to have that happen, so there's no reason that you don't want to give OSHA a reason to show up. One of the reasons they may show up is if that notice is not posted. So we recommend posting. Also, an employee who's taken the step of reaching out to OSHA to complain about the employee, whether the complaint is legitimate or not, that employee obviously believes that there is a real risk or has some problem with the employer. There's no reason to give that employee further reason to be agitated with the employer. Go ahead and post the fact that OSHA has taken action on that, and you in fact are taking action by engaging in a full inspection and investigation. All right. Now, strategies for dealing with with this process and these complaints. The most important step for an employer to take is to legitimately and actually conduct a thorough investigation. I mean, listen, folks, if there is a vulnerability, if there is a health and safety problem, and if an employee has already taken the step of reporting that to OSHA, there is zero gain for you ever to not know what your vulnerability is. If there's a compliance deficiency, you want to know about that. If there's a hazard out there, you want to know about it and you want to fix it as promptly as humanly possible. So conduct a thorough investigation. Document the investigation process, the scope of the investigation, and the findings that you make in the response to OSHA. Now, I'm not sure all counsel would recommend that, but it's our experience, it's my experience, that taking that step is far more likely to do two things. One, make sure that you are fixing any vulnerabilities and opportunities that you have for improvement in the facility. And two, you are assuring the agency and thereby the employees that you are fixing any compliance issues and dealing with any vulnerability. When a thorough investigation is conducted and a thorough response is provided to the agency, that being the end of the process vis-a-vis OSHA. That is, we have not had an instance where we've handled one of these in the manner that we're suggesting that has resulted in an on-site inspection. So we've got a pretty good database of handling these, so it works. All right, now, having said that, let me share with you and assure you that, remember, this is not a subpoena situation, so you've got some discretion in terms of what you share with the agency. You can develop, as Lindsay was explaining when you provide position statements for whistleblower complaints, you develop your narrative, all right? Do not lie, do not mislead, but present the findings that you have made based on your thorough investigation in a manner that assures OSHA that either there was not a basis for the alleged hazard complaint. That is, we've investigated, we found that, we're not sure what the complaint was, but we know that there is not a health and safety violation at the workplace and our workers are safe in this particular arena. Either that, or to the extent you did have some vulnerability. You don't need to make an outright legal admission. What you can do is share that having investigated the situation, you've determined that taking the following steps, which you are going to do immediately or provide the time frame in which you're going to take them, will ensure the health and safety of your employees. So if you find vulnerability, figure out how to fix it, and fix it immediately so you can either tell OSHA, if this is feasible and possible, that it's been dealt with already. These are the steps I have taken. These are the corrective actions that you have implemented already. And provide backup for that. Show pictures. Provide, invoices, whatever you have to document that you have taken corrective action immediately and already. Or if it's not a situation where something can be done overnight, which is often the case, even in a couple of weeks' time, this is the plan for action. And be as specific as you can with time frames, in the next quarter, by the end of, the next month, you will take the following steps. So you inform OSHA of the corrective actions and the improvements, and you do that in a manner without identifying or admitting a regulatory violation. And as I said, knock on wood, so far 100% success in terms of that being the end of the process. It's been a good process because although it's taken some time, you've made some improvements at your site if that's necessary, and you have ended any further investigation that OSHA might make. The final recommendation in terms of a strategy is don't blame the employees. It doesn't work. You may feel like it sometimes if there's truly no basis for the allegation, but it doesn't. It's not a winning strategy. OSHA's not going to buy it. It's going to make you suspect. Even if you feel it, don't say it. Don't blame the employees, and fix what you can. There's always, as we say in the OSHA world, there's always room for improvement. If you can make some improvements, albeit minor in some cases, it's a good step in the right direction, and it often assures the agency and ends the investigation. Final point that I would make on this is go ahead and ask OSHA for a closeout report. Now, the agency, it's very, it depends on the area office whether you'll be able to get one of those or not. Obviously, you'd love one. I always ask, and sometimes the OSHA will give a closeout report. Sometimes they give them without even requesting, but I would request one and see if you can get one, and then keep that in your file with the documentation of your response along with the initial allegation. And don't forget to post your response. You've already posted your the notice, and in fact, I would try to keep those things as close to possible the same time. So post the notice along with the response if you can, so that the employees can know what you've done to fix the situation to the extent that's necessary. At the same time, they know of the complaint. All right, finally, in the remaining time that we've got, we want to talk a little bit about OSHA Rapid Response Investigations, RRIs. Most of you, I'm sure, know what an RRI is. It's similar to, but different from, the Notice of Alleged Hazard phone and fax complaint that I just talked about. An RRI is an investigation that OSHA engages in response to an employer's report of a severe injury. As you know, OSHA has regulations requiring the reporting of certain accidents and incidents at your workplace. It used to be called the Fat Cat requirements. Now OSHA has changed changed fairly significantly what is reportable. We're talking now just about reportable incidents, not recordable incidents. We're not talking about the 300 logs. We're talking about actual reports of either a fatality or an inpatient hospitalization that has to be made to the agency, an amputation, a loss of eye. I'm not going to spend time talking about what is reportable. We have another webinar that I believe we've done this year already. I'm looking at Lindsay because I think she did that. We do these and we write about it all the time. But you hopefully know out there what is reportable. Once you report an injury, just like with a complaint that comes in for a phone and fax, OSHA has to make a determination as to whether to expend their resources to go out and investigate, do an on-site inspection of that injury to determine whether there was a failure, a regulatory failure, or whether it will do what is now called an RRI, a Rapid Response Investigation. The benefit to an employer for OSHA's determination that it will do an RRI is the employer gets to, which you likely would be doing anyway if you have an accident at your work site, you get to perform your own investigation into the incident and share your findings with OSHA to sort of head them off from doing their own investigation. So that's what an RRI is. Okay, let me spend just a couple of minutes telling you when, just like I did with phone and fax, when will OSHA do an on-site inspection versus giving an employer an RRI letter. Category 1 accidents. Category 1 accidents are always going to get, pursuant to OSHA policy, a mandatory field inspection. All right? That includes all fatalities. So if you have a fatality, OSHA is going to conduct an on-site inspection. If you have an inpatient hospitalization of 2 or more employees, OSHA also, per policy anyway, is going to conduct an on-site inspection. Now you recall that the reporting criteria has changed. Now you have to report even 1 hospitalization of an employee They're not necessarily going to conduct an on-site inspection, though, if it's just one employee hospitalization, but 2 or more, OSHA will be there. Injuries to young employees. If you have an employee who is younger than 18, OSHA is going to conduct an on-site inspection. If you have a known history of injuries of similar type in the last year, and again, this is OSHA's policy, which they can deviate from. You can't hold them to this policy, but per policy, they will, if within the last year they have evidence that you had similar or the same type of injuries, OSHA is going to conduct an on-site inspection. If you as the employer have a history of willful, repeat, or failure to abate violations, OSHA is going to conduct an on-site inspection, at least pursuant to policy. And again, remember, OSHA's got a limited number of resources, depending on the area, the day, but at least their policy indicates that for willful, egregious, repeat, or failure to abate violators, OSHA will not allow the employer to do an RRI, but rather will show up to do an on-site inspection themselves. If the issues that are associated with the accident are associated with or covered by a national, regional, or local emphasis program, OSHA, per policy, is going to conduct an on-site inspection. So, for instance, if you have an accident resulting in an amputation, because OSHA has a national emphasis program for amputations, they're going to conduct an on-site inspection. Trenching in construction, similar thing. Any report from a SPEP employer. So if you are on unfortunate enough to be on OSHA's list of severe violators, you will get an on-site inspection rather than an RRI. And finally, if OSHA believes, based on your phone report, that there's an imminent danger that exists at the workplace, OSHA is going to show up and conduct an on-site inspection. All right, Category 2. I've got 2 slides here on Category 2, and I think we're going to have time, by the way, to, I think we're going to have time to finish up and maybe take a few questions if anyone has any. So let me just run through what Category 2 is. Category 2 incidents are those incidents for which OSHA's area director has discretion to decide whether to show up and expend the resources to conduct an on-site inspection or put you in the category of an RRI. Here are the factors that OSHA uses in making that discretionary decision. They ask themselves, was an employee exposed to a very serious hazard? Okay, and here's some examples. Explosive materials, combustible dust, falls. There's a difference that OSHA will bring to bear in making this determination as to whether someone, has a concrete barrier in a parking lot, for instance, and an employee trips versus having some terrible burn based on, a chemical exposure. Now, I'm not suggesting that trips and falls, aren't important hazards that have to be dealt with at the workplace. OSHA has a walking working surfaces regulation. You have to be in compliance. But OSHA also has to make determinations every single day, each area office, as to where to spend its resources. And if it's a more serious hazard, they're more likely to show up. Have the work conditions that resulted in the report been corrected, and how quickly were corrective measures put in place? To the extent that and I'm going to talk about strategy for what you say on the phone, but to the extent that the report that OSHA gets, either in the first instance or in a follow-up call, because you may get one, I'll talk about that, assures OSHA that this accident happened, but the corrective measures have been put in place that provides OSHA solace that this is not going to happen again. They're more likely to put you in the category of an RRI. They still want an investigation, but they're more likely to have an RRI than show up. Can abatement be implemented before an OSHA inspection? It's really similar to what I just talked about. Are employees still exposed to an underlying hazard? This all sort of relates. If OSHA believes that your workplace has a hazard that has already resulted in a hospitalization of 2 or more employees, if they believe that is a continuing hazard, they are much more likely to show up to conduct an on-site inspection than allowing you to go into the RRI category. Did the incident result from a safety program failure? Is this a programmatic or systematic failure, or was this a one-off, an isolated incident where you seem to have a solid program in place, but something went awry? Did the employer have work rules to address this condition? And were they being communicated to employees? You know, all the things that typically go into sort of an employee misconduct analysis. Have you done a good job of developing programs, communicating those programs, and enforcing those programs? To the extent you have, you're more likely to be put in the RRI category. Just a couple of more. Were temporary workers or vulnerable work populations involved? If they were, you're much more likely to get an on-site inspection. As you probably know, the last administration made a big focus on temporary workers and the vulnerable work populations. That emphasis and focus carries into this administration, and if there are temporary workers involved, more likely to be have an on-site inspection. Was there a government referral? Did this is this incident associated with some other agency referral? If so, commence an on-site inspection. Does the employer have a prior history, inspection history? OSHA is going to look at your inspection history to make determinations as to whether they ought to show up or not. The less number of negative inspections you've had, the better. The more number of inspections with non-compliance found, the more likely they're going to show up. Is there a whistleblower complaint involved? If there's a whistleblower complaint involved or a whistleblower inspection pending, again, you're more likely to go into the category of the commencement of an on-site inspection. Finally, just a couple other factors. Is the employer a cooperative program participant? Are you in a VPP, a SHARP, a strategic partnership with OSHA, an active alliance member? All of those things are going to cut towards you being put in the category of receiving an RRI request letter rather than an on-site inspection. And finally, did the incident involve chemical exposures, heat stress, or other health issues? To the extent that they did, or to the extent the incident related to those type of exposures, you're likely to get an on-site inspection. All right, now, before I move on, I want to talk to you just for a minute about how does OSHA know the answer to some of these questions in order to make that discretionary call. And I guess what I want to share is that there's a whole strategy on, how to call OSHA, make sure you're timely, what information to share with OSHA. The desk officer taking that call has a questionnaire, and they are going to ask you certain questions that will provide them, to some extent, the information the agency wants and needs in order to make this discretionary call as to whether to commence an on-site inspection. If, however, the agency doesn't have enough information pursuant to that initial call, you may get a second call, a follow-up call from the area director, from the area office to which you reported, or the assistant area director, asking further information. And we're happy to share our advice and strategy on how to handle those calls. It really is a sensitive situation, or it could be a sensitive situation, where you want to provide enough information to assure the agency that you're acting promptly to deal with the situation that caused the accident in the first place, but not to provide so much information that, could result in an on-site inspection. So, strategically and carefully make determinations about the information that you share. But, my bottom line is you are going to have to share enough information. If you feel like an on-site inspection is not, warranted, you're going to have to share enough information with OSHA to make that determination, for them to make that determination themselves. All right, category 3. If you don't fall into Category 1, and OSHA uses their discretion with the questions that we just discussed for Category 2 to put you in the RRI, or you don't fall in, all those questions are sort of irrelevant because maybe it's a particular, sort of a minor incident that resulted in a pretty major event, though. Hospitalization of 2 employees is never going to be minor. You will get a Category 3 Rapid Response Investigation Letter. What is this, for those of you who don't know? This is a investigative tool that OSHA uses to make determinations about what caused the accident and have you dealt with the situation that caused the accident. It will show up as a letter that you get from OSHA. It's mandatory in the sense that it's mandatory in the sense if you do not respond, you will get an investigation. OSHA will begin an inspection on site. What you do with the RRI, you conduct a root cause accident investigation, which I assume you would be conducting anyway because you had either, well, if it's a fatality, you're going to have an on-site inspection, but you had a hospitalization of 2 or more employees. So you're going to be conducting a root cause accident investigation regardless for your own purposes. So the RRI is designed to capture what you determine are the root causes of the accident. You're to document your findings of that, sort of causal relationship between the root causes and the accident, and you're to document the corrective action that you've either already taken or that you're planning to take to deal with the situation. You are to post the letter and provide a copy to the union and safety committee if you have a safety committee and if you have a union. Now, there's some question as to the legal authority OSHA has currently to require the posting of the letter, but OSHA will tell you to, and it is our advice that you ought to post. And in fact, OSHA will send along with the RRI investigation letter, they will send a certification card for you to certify that you have in fact posted, you have provided a copy to the union if there is a union. All right, here are some statistics that we've looked at to sort of gauge for you when OSHA is conducting and how often OSHA is conducting on-site inspections associated with hospitalization reports, 2 or more, and amputations versus providing an RRI off-ramp. And by the way, an off-ramp means only that you, as the employer, has the opportunity to provide OSHA the results of your investigation and your root cause analysis and your corrective action determinations, before they conduct an on-site inspection, and hopefully that will head off an on-site inspection altogether. All right, for hospitalizations, you see we've got a trend that, it's about the same over the last few years. We've got data from 2015 to 2018, where OSHA receives a report of hospitalizations. In 2018, the last year for which we have full reporting data, 27%, just a little over a quarter of those 9,135 reports resulted in an on-site inspection. So the large majority, nearly 3/4, resulted in an RRI. For amputations, on the other hand, and remember, OSHA has a national emphasis program for amputations. For amputations, first of all, the number of amputations was far less than hospitalizations, about 3,000 in 2018. OSHA did an on-site inspection for nearly half, 48% of those reported amputations. So just a little over half got RRIs. All right, well, so I think this may be the let me end with some best practices. All right, and these best practices, I think one of the reasons we lumped together with the whistleblowing discussion with the phone and fax complaint and the RRI investigations, these sort of cut across all three of those, more or less, all three of those categories of complaints and investigations that employers deal with from time to time. One, thorough investigations. There is no situation that I'm aware of that not conducting a thorough investigation makes sense. There are ways to, document that. You, in some situations, may need or ought to have a lawyer involved in some of those documentations, but you always want to conduct a thorough investigation. You want to, and that means not just reviewing, not just talking to injured workers or the complaining workers or the workers who work with the complaining workers. That means talking to witnesses of those who were injured. That means reviewing applicable documents. That means sometimes not only your programs that are implicated, your safety programs, but even email chains. You want to know what happened. You want to know why an employee is complaining, and you certainly want to know why an employee was injured. Be strategic about what information is provided to OSHA or in the whistleblower situation to the employee, and how that information is conveyed. It doesn't mean conduct a non-thorough investigation, but it means be strategic, and we can spend time offline talking about what that means if you ever get in a situation like this or dealing with an RRI or a phone and fax or a whistleblower complaint. You don't need to document an admission in order to provide a thorough and sound response to the agency. For RRIs, use OSHA's non-mandatory investigative form. OSHA sends you the form that it is a table, essentially, with the question and a place to fill in the answer. Our recommendation is strategically you're better off using that form than not. Some employers choose to not use the form and to basically write a narrative. I think perhaps the reason they do that is they can, more easily sort of provide their narrative. But it's our view that OSHA, the entity on OSHA's end, the desk officer equivalent who receives these documented responses, is used to these forms. These forms are what OSHA sees all the time in the area office. They're used to going through them. They're used to checking them. If you send, say, a letter that doesn't, follow this non-mandatory form, OSHA's going to immediately, almost by definition, put that into a different category. And in our view, there's a good chance that it's going to receive higher scrutiny. OSHA's going to have to really go through that because they're not used to looking at it. That higher scrutiny may result in something that you're trying to avoid, which is an on-site inspection. So we like the form, we use the form, we strategically advise our clients on how to respond to some of those categories, especially some of the questions on the second, sort of towards the latter half of the form. Do not list employee misconduct. Just like I said earlier, don't blame the employee. Don't list employee misconduct as the first or sole cause of the injury, if at all possible. Now, that doesn't mean that it's not your view after doing a thorough investigation that employee misconduct didn't play a role. It may well have. It often does. If that's the case, you can list it. But it's our view that listing it as sort of the reason or the primary reason even of an accident happening that resulted in 2 employee hospitalizations is not going to fly with OSHA. Maybe there was employee misconduct, but there may be some other things, root causes, that you identify in your thorough investigation that you want to focus on with the agency. That will resonate with them. And it will resonate with them if, our last point here is, you've got to correct the problem. Regulatory violation or not, people went to the hospital, or an amputation occurred, or a loss of an eye. You want to improve your facility so that that does not happen again. Whatever decisions you make about what that corrective action should be, that should be shared with OSHA. All right, well, on that, I think we have concluded the bulk of our program. let me just take a minute here to check on questions. Does OSHA make formal agreements with delegated states that the state will do the RRI or on-site inspection? I assume there's always a retention of jurisdiction, but I wonder if the assumed regular course is the state will take the lead. On RRIs, the state does take the lead. The state takes the lead in conducting that investigation. I do not believe there are formal arrangements that are publicly available anyway, that deal with the specific to RRIs, but the sharing of authority that exists between state plan states and the agency applies across the board to RRIs, as well as, by the way, notice of alleged hazards. If you're in a state plan state, your notice of alleged hazard, your phone and fax complaint, is going to come from the state plan entity, not from federal OSHA. That's the agency that has authority to investigate these alleged hazards. We're asked if we can share a copy of OSHA's RRI questionnaire. I'm sure we can probably provide a question of the RRI questionnaire along with the slides that we include. We'll add it as the last slide in this presentation before we send this out. All right, well, we're a little bit past 2:35. A little bit past, I think, our cutting off time. So I'm just checking with Lindsay to see if there's anything else we want to add before we conclude. If there are other questions, we can certainly follow up with you individually to respond to those.
Yes, if I see there are some other questions that have been posted, so we will definitely follow up if there's any that we determine haven't been answered by the presentation. These last couple slides just show the upcoming webinars that we have for both our OSHA webinar series as well as our employment webinar series. So some really great ones coming up. Hope you all can join us for those as well. And then we will, again, respond to any questions that were not addressed. So thank you all very much for your participation in the webinar today. Kate and I both, love this material, very interested in OSHA and employment issues. So if you have any questions, always feel free to reach out to us by phone or email. And we look forward to having you all participate in the webinars in the future. Thanks very much.